My Lords, I have listened with great care to the various speakers who've articulated their views during this group of amendments. It has been a very profound and a very interesting debate. I'd like to thank all contributors. As I said at second reading, the bill does not seek to limit access to abortion. It could never result in a patient who had expressed a wish not to be resuscitated in an advanced decision being forcibly treated. It wouldn't result in treatment, hydration or nutrition being withdrawn from someone who wanted to live. For the avoidance of doubt, my Lords, it's only about enabling medical practitioners to withdraw from treatment which they perceive for moral or philosophical reasons or for reasons of belief to lead inevitably to death, whether of a living person or of an unborn child. It's not about doing things to patients. It's about some medical practitioners not having to do some things. And I want to just allude for a moment to the various contributions on the subject of what Lady Hale said, and to endorse what the noble Lord Alton has said, that Parliament could have envisaged the way in which the abortion law would develop. Lady Hale chose the narrow meaning on the basis that it is more likely to have been in the contemplation of Parliament when the Act was passed. She acknowledged the existence of a broader interpretation. As the noble Lord McCall very clearly said, we have the right as a Parliament to change things. And what I am suggesting is that what we need to do now is to contemplate the situation in 2018, not the situation in 1967. So it's not about refusing people access to treatment. And there have been suggestions that it's about denying patient autonomy. But I would like to say, my Lords, that a patient does not have and never has had the right to compel a particular practitioner to do a particular medical procedure. What they do have is the right to a service and the right, if they want it, to a second opinion, and that must continue. Treasury statistics show, my Lord, that the NHS deals with over 243 million patients a year, 1 million every 36 hours. It's an astonishing figure. It's a vast organisation. It undoubtedly has the capacity to provide reasonable accommodation for those of its medical practitioners who are conscientious objectors in these very limited areas. The NHS, as Lord McCall again said, employs almost 1.2 million people. And I think, therefore, it is possible to allow midwives and doctors who have conscientious objections to termination of pregnancy to care for the 700,000 women who give birth in our hospitals in England and Wales every year, to help those for whom conception is difficult or seems impossible, as the noble Lord Winston has done with such success over so many years, and those working in gynecological departments, helping women suffering from a huge range of gynecological conditions, some of which are really very disturbing of their lives and interfere with their ability to walk and things like that, to move around freely. We have, my Lords, a shortage of obstetricians, gynecologists and midwives, and of course of nurses. Part of the reason for that is that people don't apply for jobs in these areas. I have heard this from many practitioners. The noble Baroness Thornton suggested I didn't produce evidence. I suggest she rereads my second reading speech, not least the reference to the inquiry which was conducted here in Parliament on conscientious objection to abortion and the consequences of it. So, my Lord, just perhaps to suggest that it has been suggested in the context of management jobs, such as, for example, clinical leads, that it's necessary to require that there be no right of conscientious objection because abortions must be scheduled, etc. But I don't think it's quite as simple as that. I think we can agree that no one person, no matter how brilliant they are, has absolute professional capacity in every area affected by their area of clinical responsibility. Solutions are possible and exist and are practiced to address any difficulties. So, for example, a clinical lead may have deputies, and such a person might be the one to take responsibility for that area of activity, allowing the person who has a conscientious objection to withdraw, but to progress through their careers into management, whilst providing a service in all the areas, for example, of obstetrics and gynecology, to which I referred a minute ago, facilitating and enabling conception, care of pregnant mothers, delivery of those 700,000 births each year, and the care of those suffering from gynecological diseases and other conditions. My Lords, I think it would be most helpful if we could discuss further the amendments in Group 1 to see whether we can agree how reasonable accommodation might be achieved or provided for, and so improve the service available to patients while protecting practitioners. I think we can reach a situation, given the goodwill which has been expressed in this House, in which we could ensure that services will not become difficult to access because of it, and that services will still be there. My Lords, there are some 60,000 abortions in the NHS each year. The rest are conducted in private clinics. The number of 60,000 is actually a small percentage of the totality of the work of practitioners in obstetrics and gynecology, where we have those 700,000 births a year and all the other work I've referred to. The bill does not take away the NHS or the government's duty to provide services. That duty will remain. All that will be required of the NHS is reasonable accommodation for a limited number of people. And, my Lords, of course, reasonable accommodation is recognised and accepted by all the Royal Colleges. My Lords, some of the amendments in this group seek to remove from protection the proximate forms, all the proximate forms of assistance, cooperation, supervision, planning and delegation, through which a medical practitioner may be implicated very closely in the activity to which they conscientiously object. My Lords, as has been said, supervising, planning or delegating the doing of X means making sure that X is done, and most importantly, that X is done right. The aim of the bill is precisely to protect conscientious objectors from coercion through this type of involvement in matters intrinsic to the taking of life or the withdrawal of life-sustaining treatment. My Lords, having listened carefully, I do believe that as a Parliament and as a country, we can afford and manage to provide protection to those for whom conscience makes activity designed to end life untenable. Forcing people to act against their conscience, leaving them in a position in which they never know when they will have to do something to contribute to the ending of life. Accepting that hostility and exclusion are legitimate reactions to an avowed and profoundly held belief, for some a religious belief, for some a philosophical belief, cannot be right. I have been told by members of this House and by many others of the ostracisation which can make life so very difficult for those who want to provide medical care to sustain and enable life, and to manage the dying of those who must die with the greatest possible levels of palliative care. It is unacceptable in a society which is proud of its historical contribution to the evolution of the fundamental British values of democracy, the rule of law, individual liberty, and mutual respect and tolerance of those with different faiths and beliefs, if we do not have a proper, modern, appropriate law of conscientious protection. So in concluding, my Lords, I would urge those who have tabled these amendments to talk to me, to talk to us, so that we can discuss a way forward which would meet their concerns. As tabled, these amendments will not enhance the situation of all those who are regulated by the organisations in Section 1(2) of the bill. And we will come back to that, but it's a very important part of the bill. Nor will they enhance the experience of patients. Patients will still be able to accept the same services. And it is possible, my Lords, to provide autonomy for patients and to protect conscientious objection of medical practitioners. They are not mutually exclusive services, mutually exclusive recognition, perhaps, of the human rights of which Lord Brennan so eloquently spoke.